All right, thank you everybody for being here today. We're going to go ahead and get started. It's at least 4 o'clock by my clock, so we'll start our meeting today. My name is Natalie Mast. I am the Active Management Area Director at ADWR, and today we are here to talk about some of the requirements that we have in the Hualapai Valley Irrigation Non-Expansion Area. And after we do a short presentation here at the beginning, we'll have staff in the room until 6 o'clock to help with any specific application questions or specific situation questions that you may have. For those of you in the room, we do have some information over on the table here and also a sign-in sheet. The sign-in sheet is specifically to add you to our email list so that when we have meetings like this or other types of announcements, you can get an email from us for those types of things. But with that, I'll go ahead and jump into, if I can get my slides over. There we go. I'll go ahead and jump into the presentation. So like I said, we are going to go over some of the requirements in an INA, what the restrictions are on irrigating lands, what the reporting requirements are, what the measuring requirements are. After that, we will talk a little bit through the application process. And like I said earlier, we will, after that, have some time for specific application support or answering specific questions. Over on the table over here, for those of you in the room, we do have a little half sheet of paper with some information on it about what we're referring to as office hours. So we are holding weekly virtual office hours. So if you have questions that you might not be able to get answered today, we do have weekly online office hours where you can just log in anytime during that hour each week, and we'll have a staff person online during that time to help answer your questions. All right. I'd like to introduce the ADWR folks that I have with me today. In the front here is Teresa Marks. She is our outreach coordinator, specifically for the Douglas and Hualapai, the Hualapai INA and the Douglas AMA. I have Brandon Thalman here, who's my data specialist. Ben Calleros is one of our attorneys. Mike Ortiz is my establishment coordinator, and I lost Reyes. Reyes Huron is from our Wells team, so he's going to help with any Wells questions that you may have. So with that, we'll go ahead and jump in. For those of you online, we do ask that you keep your audio on mute so that we're not interrupting the meeting. If you have any questions, you can type them into the chat and we'll try to answer them as we go. The presentation portion of this will be recorded today and will be posted on our website once that recording is available. All right, so we have a few terms that we're going to use throughout today that are going to be really important. The first one being irrigation. This is an irrigation non-expansion area, and this term irrigation is something you're going to hear a lot. And it's really important to remember that our view of irrigation is something very specific. So for ADWR's purposes, we have a statutory definition of irrigation. It's defined by law, and that is the application of water to 2 or more acres of land to grow plants or parts of plants for sale or consumption. So if you are applying water to a field to graze cattle on, that would be considered irrigation because those cows are then eating those crops. But if you are watering 1 acre of garden in your backyard, that's not considered irrigation from our perspective because it's less than 2 acres. So that's an important distinction for our terminology, is that it's specifically 2 acres or more. Another important definition here is related to wells. An exempt well has 3 criteria that define it. The pump capacity is 35 gallons per minute or less. It doesn't use more than 10 acre feet for a non-irrigation use, and it's not irrigating 2 or more acres of land. So if it doesn't meet any of those 3 criteria, then it would be considered a non-exempt well. Exempt wells are kind of what they sound like. They are exempt from any monitoring or reporting requirements. But again, they have to meet all three of those criteria. All of our reporting and our volume measurements for ADWR are measured in acre feet. An acre feet is just a common measurement of volume of water. That's equal to 325,851 gallons, or the amount of water that it would take to fill 1 acre of land 1 foot deep. So for a couple of these, I'm going to repeat particularly that irrigation and exempt well definition throughout the course of this meeting, but I wanted to introduce these up front because these are going to be really important terms as we work through this. So ADWR was created in 1980 as a part of the Groundwater Management Act. That act created the Arizona Department of Water Resources and created a regulatory structure around groundwater in the state of Arizona. Most of those regulations are limited to areas designated as either irrigation non-expansion areas like the Hualapai Valley or active management areas. And that act also authorized the establishment of new INAs or AMAs, either by initiation or by designation of the director. The general structure of the Groundwater Management Act is additive. So there are some requirements that apply statewide. Statewide, you are required to register any well before it is drilled. There are adequate water supply notification requirements, and water systems, municipal water systems, community water systems are required to report their water use on an annual basis. An INA adds another layer onto that. So an INA has to comply with all of those first requirements and also some additional requirements. So an irrigation non-expansion area is kind of what it sounds like. The expansion of new irrigated acres, the expansion of any irrigated acres is prohibited. And irrigators and non-irrigation users who are using more than 10 acre feet of water per year are required to submit annual reports to ADWR. In an AMA, in an active management area, there's yet another layer of requirements, where in AMAs, there are assured water supply requirements, which is a stronger version of the adequacy requirements. We also have management plans, goals, and conservation programs in AMAs, and there are specific volumetric grandfathered rights and withdrawal permits in active management areas. This is the Hualapai Valley INA, so we're going to be focusing on kind of that middle portion here today. Under the Groundwater Management Act, there were 4 AMAs established and 2 INAs established. The initial 4 AMAs were Prescott, Phoenix, Pinal, and Tucson. The Santa Cruz AMA was split out from the footprint of the Tucson AMA in the early 90s. And the Douglas Active Management Area was created by local election last December. The initial INAs were Joseph City and the Douglas INA that was recently converted into the Douglas AMA. The Harquahala INA was designated by the director in the early 80s, and Hualapai Valley is our most recent INA and was designated by the director in December of last year. The reason I want to point this all out is because we're in a really unique moment. All of the initial footprint of these regulated areas was created in the early 80s, except for Hualapai and Douglas. So until last year, the footprint of these regulated areas had not changed. So that's important to note that this is really a new thing. We're working through very new processes. We have very, very different technologies and tools available to us than we did the last time we did this. So there are some things that we're having to establish new processes for and figure out exactly how things are going to be administered in this instance. So like I said, Hualapai is the second subsequent INA that has been established in the state. It was originally considered to be an INA by requests from Mojave County. The INA itself is located entirely in Mojave County, and you can kind of see a map of where it lies on the screen here. We do have these maps available online. We also have interactive GIS maps that we can point you all to if that would be helpful for understanding better where your property lies. So, in order to establish an INA, we have to work through the items that you see on the screen to kind of set up all of the structures that we need to have in order for the INA to be operable. The first and kind of the most significant here is the prohibition on the irrigation of acreage that was not historically irrigated. I'm going to go into a little bit more detail in a few minutes on what that means. We also have a requirement for measurement of all withdrawals from non-exempt wells. So greater than 35 gallons per minute, or withdrawing 10 or more acre feet for non-irrigation use, or irrigating 2 or more acres of land. That's a non-exempt well, and if you meet any of those 3 criteria, then you have to report the withdrawals from that well. And in order to report those annual water withdrawals, you have to obtain an irrigation authority, which provides you with a reporting number. We call it a 60 number because the first 2 digits of it are always 60. And you use that number to file your annual water reuse reports and report to the department any changes in the boundaries of your property. So this is a little bit small, but I'll work through it to help explain what we mean by no expansion of irrigated acres. In an INA, only lands that were legally irrigated during the 5 years prior to the initiation of proceedings to designate the INA may be irrigated going forward. So again, irrigation specifically being 2 or more acres, application of water to 2 or more acres of land to produce plants or parts of plants for sale or consumption. So only lands that were irrigated between October 12th, 2017 and October 12th, 2022 may be irrigated going forward. There are some limited exceptions to that, but that first point is really important because only acres that are deemed to have been irrigated during that time period may be irrigated into the future. This prohibition is permanent. So our exceptions here are that acres that weren't irrigated during this land may be irrigated with a surface water right that was established prior to the date of the initiation of proceedings. There's a typo on my slide. I apologize for that. I'll make sure that gets fixed before we post these online. So it may be irrigated with surface water right that was established prior to the initiation of proceedings. That's not really going to be terribly applicable here because there is not a lot of surface water here. Acres of land that were not irrigated during our time period, October 12th, 2017 to October 12th, 2022, may be considered to have been irrigated, and by that we mean they may be eligible for irrigation in the future if substantial capital investment was made to bring that land into irrigation. Substantial capital investment is complicated. Substantial capital investment is a very, very case-by-case consideration, and it's not something we're going to be able to provide direct advice on a direct case. What we recommend to folks is that they seek legal counsel and that they submit whatever information that we can that might help us consider the amount that might have been invested in the appropriate time period. Substantial capital investment must have been made between October 12th, 2017 and October 12th, 2022. And the language associated with what's eligible for substantial capital investment is on the screen here. So for the subjugation of such land for an irrigation use, including on-site irrigation distribution facilities and a well or wells, the drilling and construction of which were substantially commenced prior to October 12th, 2022. So I understand that that's a lot of legal language, and I understand that's complicated. And again, this is a very fact-intensive thing. This is a very case-by-case thing. And if you have specific questions about your instance of substantial capital investment, we would really encourage you to seek legal advice about that. For measuring and reporting. In an INA, non-exempt wells must have a water measuring device. When the INA was established, there was a deadline for water measuring devices established, which was March 31st of this year. So you are right now required to have a water measuring device on every non-exempt well. So if a well is withdrawing, it has a pump capacity with a maximum capacity of greater than 35 gallons per minute. If that well is withdrawing 10 or more acre feet annually for a non-irrigation use, or if that well is irrigating 2 or more acres of land, it must right now have a measuring device on it. That could be a meter. Most of the time what we see is totalizer style meters, or we do also have on our website and in our rules approved alternative devices for the measuring of that water use. Each person withdrawing groundwater from a non-exempt well must file an annual water use report. Annual reports are due by March 31st of each year. So the first annual reports for the Hualapai Valley INA will be due of March 31st of next year of 2024. And again, note at the bottom, these requirements do not apply to exempt wells. So if you don't check any of those 3 boxes listed under non-exempt well, these metering and reporting requirements do not apply. Anyone claiming a right to irrigate land in the Hualapai Valley INA must obtain an irrigation authority. And that's part of what we're here today to help with, is those applications and the process associated with those. Again, irrigation, applying water to 2 or more acres of land to produce plants or parts of plants for sale or consumption. This is important. If you are irrigating less than that, you are not required to have an irrigate. If you're applying water to less than 2 acres, then you are not required to have an irrigation authority. If you are applying water to more than 2 acres, you are required to have an irrigation authority. Anyone irrigating any land in an INA without an irrigation authority can be subject to compliance action. So that's why it's really important to apply for those irrigation authorities. When we issue an irrigation authority, it provides the water user, the landowner, with a right number. And I mentioned that it's a 60 number, 60 and then some additional digits after that. And that 60 number is then used for annual reporting purposes and also for things like changes of ownership or changes to parcel numbers, those types of things over time. It's kind of our water rights management number. Application fees. There is a fee for applying, and I understand that this initial fee looks high. It is. We understand that. I'll get to how we're changing it. So right now, as of today, the fees for applications are based on an hourly fee. There is an initial deposit of $1,000, and that $1,000 is billed against on an hourly rate of $118 per hour. So what that means is we take a $1,000 deposit when you submit your application, and the time it takes us to process that application is billed against that $1,000. If it takes us less time than what would add up to $1,000, we would refund that money. If it takes us more, we would bill against that. We heard very, very extensive feedback at the beginning, at the establishment of the Hualapai INA, and also at the establishment of the Douglas ANA, with very, very extensive concerns about that $1,000 fee. It's high. We very much understand that. And on May 5th, ADWR submitted notice of an expedited rulemaking to change those fees, to lower those fees. So this is in process. Rulemaking processes take time. So as of today, we're still under that $1,000 initial fee and hourly structure, but we are working on changing that fee to a $75 per application flat fee. The rulemaking does have to go through a legal process. There's a hearing for that scheduled at the end of this month. It'll go to the Governor's Regulatory Review Council, and assuming that the Regulatory Review Council would approve it, that rule would go into effect in August. So you can see a little bit more of that timing here. We published our rulemaking in the Administrative Register in May. We have a public comment period that we're in the middle of right now. It'll go to a Governor's Regulatory Review Council review for approval in August, and assuming all goes smoothly, assuming they approve that rulemaking, that rule would then take effect in August. So we are encouraging folks to submit their applications, and also we understand that folks might want to wait until this rulemaking goes into effect because of that very significant change to the fee. There is a refund provision in the rulemaking. So anyone who submits their application now under that $1,000 initial deposit would receive a refund of the difference between the $1,000 initial fee and the $75 final fee. All right, so some of the kind of heavier stuff aside, we do have an application process for obtaining those irrigation authorities. If you are using water for a non-irrigation purpose, we talked about for our non-exempt wells, if you're using 10 or more acre feet, you are required to meter and report that. We have a separate process for establishing an annual reporting number for that. That I believe actually goes through our wells team for establishing the 60s. I can confirm that. Reyes is making faces at me, so maybe that's not quite correct. I'll confirm that, and we'll make sure that we are able to communicate how those non-irrigation 60s are issued. But in any case, for the irrigation authorities in an INA, we do have an application process for that. Our forms are all available online, but for those of you in the room, we do have paper copies of the application forms available here today that we can talk through with you. So basically, the very high-level view of the process is you submit your application with all of the associated data and documentation. ADWR will review the information in that application and use satellite imagery, use other information that's available to us to verify that data. And if that application is approved, we would issue the irrigation authority and the corresponding 60 number. In order to apply, there is a fair amount of information that you'll need to have gathered. We need a description of each parcel of land that is being irrigated, a deed for the land, and the name on the eventual irrigation authority is going to have to match the name on the deed. And then also a map of the land, including an indication of what acres were irrigated, what acres you're claiming for irrigation, because it may or may not be the full parcel. And if you're claiming any substantial capital investment, we also need an indication on that map of what that area is. We'll also need an understanding of how many acres were irrigated each year, any well numbers associated with irrigation wells, and if applicable, additional proof receipts or other dates and that kind of thing regarding substantial capital investment. We can take applications by email, or they can be mailed to the address on the screen. That address is also on the application form. Like I said, after an application and payment are submitted, ADWR does take some verification steps and takes some quality control steps. And then we may also conduct site inspections depending on the facts of each individual application. At that time, we would examine any claims of substantial capital investment associated with that application. A determination will be made of how many acres were historically irrigated or claimed under substantial capital investment. And as a part of us issuing that irrigation authority, that 60, each owner will be notified of the approved irrigated acreage. Applications in this case are able to be evaluated on an ongoing basis. So as soon as we receive applications, we are starting to review them and hope to start issuing our first irrigation authorities probably in the next month or two here. Yeah. So we will be starting to issue irrigation authorities for this area very soon. And like I said, the first annual reports for water users in the Hualapai Valley INA are due March 31st of next year. So there's not a deadline to apply for your irrigation authority, but you'll need that 60 number in order to submit your annual report in March. I mentioned the virtual office hours at the beginning. We are making, because these are brand new areas, we recognize that a lot of this information is brand new to you all. And we recognize that there are going to be a lot of questions. So we're making efforts like this meeting today, like these virtual office hours, to make sure we're making ourselves available to folks, to ask questions, to get anything answered about their application, get help with their application, those types of things. Our office hours right now are Tuesdays from 3 to 4 p.m. If that time does not work for you, give us a call and we will work to schedule a specific appointment for you to get your questions answered, excuse me. We are also setting up a computer at the Mojave County Library in Kingman. That computer will be available for checkout. So if someone doesn't have a computer or internet at home, it'll be available for you to use for application support or for filling out and submitting your application online. All of our information about office hours is on our public meetings page on ADWR's website. All of the information about applications is on our Hualapai Valley INA page on ADWR's website as well. So with that, we'll go ahead and move into the next phase of our meeting. Before I close down this presentation, Teresa, did we have any questions online? Yeah, no, okay, great. So folks in the room, what we're gonna do is, if there are any questions on the presentation, we'll talk through a couple of those now. And then we'll close down the webinar portion and we'll have our staff here talk with folks individually and can start to answer individual application questions or questions specific to your particular circumstances. Okay, are there any questions in the room?
I have one question. You mentioned the anyone claiming a right to irrigate land in the HVINA must obtain an irrigation authority.
Yes.
And I'm not an attorney and not the brightest pencil in the stack, but I can't find anywhere in the statute or rule that requires that process to happen. Could you enlighten me on that?
So in order to define those acres that are legally irrigated, we require that folks submit information to the department to define what those acres are. Basically, this is an evidencing type step to make sure that we're properly defining those acreages. There is not a deadline on submitting that evidence, but we do require that folks submit that evidence to ADWR.
No.
Or what is the compliance process?
If you guys couldn't hear, the question is regarding the compliance process. So we do have a compliance team at ADWR. Our chief compliance officer his name is David French. We also have a compliance portal where individuals in an area or interested parties can submit observations or complaints about compliance issues. So our compliance process is kind of twofold. Part of it is responding to complaints that we receive through our portal and checking on whether there's an actual compliance issue there, kind of verifying the information there and pursuing things appropriately as we find out information there. The other piece of it is more of a proactive model where we use satellite imagery and historical information available to us to determine whether what lands we might observe have been irrigated in the past 5 years, for example, for this area, and whether we're seeing any additional expansion of irrigated acres in this area. So we can use satellite imagery to analyze some of that. I will say for this area in particular, some of the satellite analysis is really difficult because things like young trees are really hard to see on the satellite imagery. So in some cases, we do rely more on the ground inspections or local input for specific compliance cases where we might not be able to see things as well on the satellite imagery. I think you might have had your hand up first, sir.
Quick question. If I own 10 sections of ground, all the prior irrigation, and I got 2 wells per section, all of a sudden I need 3 wells. I apply for an NOI. What kind of additional scrutiny is that going to come under ADWR? Like a presentation, well, legal section of ground qualifies all the requirements.
That's a great question. So the question is relating to historically irrigated acres and drilling a new well to serve water to those acres. In an INA, let me start that over. In an active management area, we do have what we refer to as well impact analysis requirements. Those do not apply in an INA. So in an INA, the only additional thing that you'll have to demonstrate in order to get that drill permit is that you have an irrigation authority. What our Wells Group is doing in the kind of this interim period while we're still accepting applications and processing those applications is they'll accept an application number. So as long as you've applied for your irrigation authority, then our Wells team will look at that as enough evidence that you're working toward getting that irrigation authority, and we'll count that toward issuing your well permit.
Time on the average NOI. Is that going to alter that timeline?
No. So all the NOIs, we technically have a time. It is going to remain on that. I just say we'll accept it and
for the webinar, Reyes was just confirming. Yeah.
So I don't have to claim that low service, basic problems, formation problems. I don't have to justify the additional need for water.
Yeah. I think there was another hand somewhere. Yes.
In the paper, there was already 6 violations. And wondering, mention how you monitor, pretty having 6, seems pretty high.
So we are actively monitoring additional land clearing, additional irrigated acres in this area. As of October, I've lost track of the date on the top of my head. As of October 12th, there is no more expansion of irrigated acres allowed in this area. So we are actively tracking any additional land clearing, any additional planting, and those types of things, and reaching out through our compliance team to those landowners, to those potential irrigators, to make sure that if they haven't started irrigating, that they know what the requirements are and are aware that if they begin irrigating, that could lead to civil penalties and a violation.
Good.
And using Douglas INA as the amount of people that try to prove that they have substantial capital investment. And let's say they had 1,000 acres. How many of those people that applied for the authority under those pretests won the right to irrigate? Under substantial capital investment.
I understand the question. So the question is, looking back at Douglas, for example, how many SCI applications might have been approved, and I'm not sure. We do have those records at the department. We have looked at some of those records in preparation for this. But again, substantial capital investment is such a case-by-case thing. I don't know that percentages are necessarily going to hold. It's going to depend on what type of evidence folks are going to be able to.
Is that information available on the ADWR website under that? Yeah.
I'm not sure. It's a good question. I'm not sure. It would be available via public records request if it's on the website.
Public information.
Yeah. Yeah.
Other than we're going to recall, according to I took what you said, but as a lawyer, correct?
Do you want to?
Yeah, I mean, it was not meant to be anything aggressive. I think we're just, I think the problem here is we're not allowed to provide any legal advice to you. And this thing is such a case-by-case scenario that in order to really give you good advice, you would need to have a lawyer give it.
Administratively.
And yeah, so administratively, I mean, you don't actually need a lawyer to submit this application at all. We just got it. Yeah, we're just saying, if you have something that you don't think is some like slam dunk application, you should probably talk to a lawyer to then see what your best options are. And we can't give you any legal advice because that's not legal for us to do. So that's why we're saying you should talk to your own lawyer who can give you the legal advice. That might help you.
Those cases are published on the website. You have to dig for it a little bit. It's there.
Thank you. Okay, I'm not seeing any additional hands, so we'll go ahead and shut down our, oh, sorry, one more.
One more. No. That came after the 1980. State legislator. For HV different, or is it going to be a boilerplate?
I'm gonna repeat the question to make sure I'm following. Are there any different, is the question, are there any different requirements for Hualapai than there were for Douglas?
That's correct.
Okay.
More or less. Is the rule book the same for any INAs prior to Hualapai Valley?
The general rulebook is the same for an initial INA versus a subsequent INA, with the exception of our kind of period of reference. So those initial INAs were their kind of period of reference for irrigation was going to be 1975 through 1980. Our period of reference here is 2017 through 2022 for irrigation. That's really the only difference.
We have one question online.
Okay.
We have a question online from John Tolton. He would like to have an example of a slam dunk SCI application.
Yeah, I will say, I should not have said that, but, so basically, I was just saying, if you felt like you didn't need any advice to put forward your application, then, feel free to just apply. Our general advice is for you to seek legal advice to help you put that together. That doesn't mean whatever you think it means. Unfortunately, we can't really give you examples. I know we do have
There are examples.
examples online of, different items in the Douglas INA, of what we were looking for showing substantial capital investment. Let's say you look at one of those examples and it fit, everything you did, you could probably feel pretty comfortable there. Again, just tell you that. So yeah, there's not
That
something
raises a
specific I
question.
can tell you.
Something that I will say is part of our application process is as we go through the application and look through the information and are verifying information, if we have any questions or need any additional information, we will be reaching back out to that applicant. It won't be something where we just deny the application because we're missing a piece of information.
Yeah, it just brought up one good question. If these fine people over here apply for something and they're denied, what is their due process right to dispute that denial?
There is an appeal process.
Yeah, so.
There is an appeal process.
So I'm gonna say, first off, with that, I was just talking about, say you submit your application and it doesn't have everything you need, we don't just deny it. We communicate to you and say, hey, there's a couple things missing, could you send us this or that? And we'll work back and forth with you, kind of bring that forward. If in the end it is denied, then yeah, you have a right to appeal that decision. Steps to that, yeah, you basically can appeal it to basically the administrative law judges or there's certain ways where you can directly appeal a state court. I'm sure you know. Lawyer up. But,
Yeah, at that point, lawyering up is probably a good
Yeah,
idea.
yeah.
Even if you thought you had the slam dunk,
Yeah,
right, you might
but-
want to.
But yeah, anyways, there are multiple avenues for you to appeal a decision if it's denied. Just not-
Right, so you guys have some sort of, notice or something that would inform them of their options of appeal.
Exactly. So
Right.
if any application is denied, attached to that letter denying it is basically all the steps you need to take to.
See, that's how it should be.
Yeah, it is how it's required to do. So.
Well, here in Mojave County, I just get, quick example, but here in Mojave County, if like code enforcement says you violated something, they don't tell anybody that they have any due process rights of appeal, and people are like completely, they don't know what to do. They know what to do. So it's on the form. That's all I wanted to make sure that these fine people would know what those rights were and wouldn't have to go fishing around trying to find them somewhere. So, all right, thank you very much. That answered my question.
Substantial capital investment. Please prove me wrong. There must be a sweet spot on per acre cost that you guys have defined to get the right to irrigate that. That includes the property fencing, the wells, the equipment of the wells, driven, the energy, either APS, this sort of any of the public utilities, and free ground prep as well. But is there a price per acre we're trying to find? How do you guys determine that?
There is not a specific price per acre. And the reason for that is that what is substantial to individual farming, that's 10 small acres or something like that, is different than a very large corporation farming thousands of acres. So we do not have a defined dollars per acre that we deem to be substantial. And that's part of why this whole thing is so case by case. It's because we take a lot of different factors into account. So unfortunately, that means it's hard to answer kind of in generalities of substantial capital investment, but it does mean that we do consider each individual on its own merits. All right, I think we'll go ahead and shut down the webinar portion now. I do really appreciate all of your attention and questions so far. We're going to stay in this room, and we, staff, will stay in this room, not all of you if you don't want to. We'll stay in this room until 6 o'clock. If you all have specific application questions, like I said, we do have some applications that'll be available here. I don't think they're out yet. And we'll be around to answer more specific questions for any of you the next couple hours here. So thank you very much.
Thank you.
Thank you.
All right, babe.